So I have prepared a PowerPoint. What I'm going to present is the multi-party interim appeal arbitration arrangement. Apparently, nobody really was thinking of a proper acronym here. It's usually abbreviated to MPIA. And it was Armin von Bogdandi who suggested that I present this, and I think it's a vital development in the history of the WTO. I can't resist. I will also say a little bit about the Ukraine situation in the WTO at the very end. Now, to understand what the MPIA does and why it's important, I have to quickly run you through how the WTO deals with disputes. The World Trade Organization has a dispute settlement mechanism that is mandatory for all WTO members. And basically it starts with consultations. Then you bring your claim forward to a panel, 3-person panel. You can appeal, but you can only appeal on the law to the appellate body. We will see that there's an issue with appeals on the law and appeals on facts in a moment. And finally, when you have an appellate body report, you get to the implementation stage of a decision where you can also haggle about whether a report was properly implemented, whether you need more time for implementation, and whether ultimately you can retaliate. The WTO dispute settlement mechanism is one of the most successful dispute settlement mechanisms in all of international law. The WTO has settled more than 500 cases, and regularly cases are brought before the WTO. Now, one important aspect of WTO dispute settlement, a bit more in theory than in practice, is that WTO dispute settlement is not really a court system. In fact, there is a dispute settlement body, which is the political body of the WTO, the General Council in which all members of the WTO are entitled to sit. And technically, when you move beyond the consultation stage and you ask for the establishment of a panel, it is the dispute settlement body that decides to establish a panel. When a panel, which is then 3 lawyers issuing a report on the dispute, when that report is issued, it is again the dispute settlement body that adopts the panel report. And it is also the dispute settlement body that adopts the appellate body report should you appeal. All of these actions by the dispute settlement body since the establishment of the WTO happen by negative consensus, which means you have a right to a panel to be established unless all WTO members agree that there shouldn't be a panel. You will get your panel report adopted unless all WTO members agree that this won't happen. And the same is true for the adoption of the appellate body report. This used to be different in the old GATT system, 1947, where there was only one stage, only a panel stage, and the adoption of the panel report happened by consensus of the members. This was changed with the establishment of the WTO to adoption by negative consensus. What happened recently is that the appellate body died. And it died in a rather tragic way. All new appointments to the appellate body were blocked by the United States. And so the terms of the appellate body members ran out. The appellate body has 7 members, and 3 of them rule on each case. And in 2019, there were only 3 appellate body members left. And in December 2019, the term of 2 of them expired, and the Chinese appellate body member was the last one left in the institution. And in November 2020, her term expired as well. And that means that there are no members of the appellate body. Legally speaking, though, the appellate body is still there. So what does that mean now for the reality of disputes? If you get into a dispute, you still have the right to your panel. You can still get a panel established. You can get a panel report. But what happens if you appeal? And the consequences of the appeal are described in Article 16, paragraph 4 of the Dispute Settlement Understanding, the DSU. It states, within 60 days after the date of circulation of a panel report, the report shall be adopted unless a party to the dispute formally notifies the dispute settlement body of its decision to appeal, or the dispute settlement body decides by consensus not to adopt the report. That is the rule of negative consensus I was speaking about. So basically, the right of appeal still exists. And if there is an appeal, if a party has notified its decision to appeal, the report by the panel shall not be considered for adoption by the dispute settlement body until after completion of the appeal. Of course, an appeal can no longer be completed as there is no appellate body. So the panel report disappears, but there cannot be an appellate body report. Basically, the losing side can, by way of appeal, make the report go away. This is referred to as appeal into the void. And when you think through the procedure, we are now a little bit like the procedure that we had in the GUT 1947 before the WTO was created. The losing side in the past GUT system could make a report go away by simply not consenting to it, because the adoption of a report required consent of all members. Now, the losing side can make a report go away by appealing. Why did the US behave in this strange way? Well, in February 2020, the US adopted a really, really lengthy report of 170 pages, roughly, describing all of the various issues it saw with the appellate body. I'm not going to run you through each and every one of them, just going to point out some of them. There are the formal ones. So, for example, the appellate body is supposed to issue its appellate body report within 90 days. That is a very tight deadline. The appellate body was pretty good at sticking to it at the very beginning of its existence, but then the cases got more complicated. And in the beginning, the appellate body asked the two litigants whether they agreed to an extension. Over time, they stopped asking, and they didn't abide by the 90-day deadline. Now, second problem the US saw is in the DSU, it doesn't say anything about members of the appellate body who are put on a panel, on these three-people panel to decide on an appeal, but whose term expires before they could issue a ruling on the case. The members of the appellate body in their working procedures adopted a rule stating once they get a case, they can continue on the case even after their term expired and issue a ruling at the very end. The US said, you can't do that. That needs to be in the dispute settlement understanding. Members of the WTO didn't agree, not okay. They also complained that the appellate body started to rule on the facts because there's a provision basically forcing the panel to stick to the facts. And the rule, which is the appeal, which is only allowed on the law, was then couched in terms of abiding by this particular provision, Article 11 of the DSU. So a violation of the assessment of the facts was regarded as a violation of the law, and that led to a lot of appeals. The appellate body also claimed that its reports were entitled to some deference, so they must be followed in future cases, absent cogent reasons. The US said there is no rule of stare decisis in international law, and particularly not in the WTO, can't do that. What seems even more important were the issues the US saw in terms of factual problems in the rulings of the appellate body. In particular, they disliked the prohibition of zeroing. That's a particular calculation in anti-dumping that allows the state taking measures against dumping to have higher dumping margins and impose higher tariffs. They also didn't like the interpretation of the safeguards agreement. We'll get to that in a moment. There has long been a debate amongst trade lawyers whether any of this is actually for real. When the blocking of members started, Donald Trump was president. There was some blocking before, but Donald Trump was the one who was president and saw the process through. But it's pretty clear that Donald Trump had very little to do with it. Probably more engaged was Mr. Lighthizer, who was the US trade representative, and he actually published articles in which he made his opinion rather clear that he didn't like the appellate body. He wanted to go back to a one-stage process, basically like arbitration. And finally, there were also complaints of Werner Stuck, the Austrian who oversaw the appellate body secretariat, who was very much involved in cases, and the appellate body members are not full-time judges. So the secretariat had quite an amount of power. But my argument would be that the largest reason for the US to actually try to get rid of the appellate body altogether is China. The US regards as a vital part of its deal for the WTO that it lowered its tariffs rather significantly, but could then impose trade remedies, safeguards, anti-dumping duties, countervailing duties comparatively easily and at very high margin. The case law of the appellate body does not allow that. We've spoken about zeroing. The same is true for safeguards, where the appellate body saw rather important requirements before you can impose safeguards. And this is likely the reason that the US wants to see the appellate body gone. Now, the reality is, since December 10th, 2019, there were 14 appeals into the void, the first one by the US. Acknowledging that situation, that practice stopped. By now, the US has appealed cases into the void 4 times, India 3 times, but even the EU has appealed into the void. China has appealed into the void. So it is by now common practice for a losing side that doesn't like the panel report. How do we move forward? There have been numerous papers trying to resolve the situation, trying to respond to all of the charges of the US. None of them led to any success. And indeed, the US has never taken a clear position what it would take to reestablish the appellate body. Arguably, I would say, because they don't want the appellate body. There is theoretically the possibility to try to have a vote on members of the appellate body on their election. But Article 2.4 of the DSU states that the dispute settlement body decides by consensus. And even beyond that, it's a practice in the WTO. You could find a legal argument stating you should have a vote, but the reality is this will not happen. So what happened instead was that members started to take their own measures. The EU in particular, as a first step, established a unilateral procedure that if a panel report is appealed into the void, it can act under its enforcement regulation. So it can then take trade measures, basically retaliating against a measure that was found illegal in a panel report that had been appealed into the void. Brazil has by now done the same thing. And the EU has spearheaded the MPIA, the Multi-Party Interim Appeal Arbitration Arrangement. The original idea comes from Peter Jan Kuiper, from attorneys at Sidley Austin, and from James Backus. The EU then put it into legal wording and originally agreed it with Canada, later extended to Norway, and then formally notified this MPIA mechanism to the WTO on April 30th, 2020. By now, it has 51 WTO members on its side. Just to point out, China has agreed to it, Brazil has agreed to it. 2 of the 3 NAFTA or USMCA partners have agreed to it. The US, of course, hasn't. Singapore, so also some of the more innovative partners in trade. What does the MPIA do? The first thing is, the MPIA is a tremendously creative piece of lawyering that is based on an existing provision of the dispute settlement understanding. The DSU allows for arbitration as an alternative means of dispute settlement. So expeditious arbitration within the WTO as an alternative means of dispute settlement can facilitate the solution of certain disputes that concern issues that are clearly defined by both parties. Arbitration exists, it just was very, very rarely used. When you use arbitration, that's para 4, you still get into the same enforcement procedures at the very end of the arbitration. It's just that you don't enforce a panel report, but an arbitration award. So what the EU did was formulate an arbitration procedure that replicates almost exactly the appellate body procedure with some slight twists. So what happens now is, at the very beginning of a case, the parties can agree that they will resort to Article 25 arbitration as an interim appeal instead of pursuing an appeal. They can notify that, or they can be members of the mechanism. They can still then go through the consultation phase and have to do so. They go through the panel phase as normal. At the very end of the panel, though, they request to suspend the panel proceedings to initiate arbitration instead. That is automatically deemed as a joint request according to the agreement of the parties. And the arbitration is then initiated by the notice of appeal. That still looks like the old procedure. You then go to arbitration by 3 arbitrators from a 10-people pool that is modeled on the Appellate Body procedure. You have the same outcomes of the arbitration. Either the panel report is upheld, the panel report is modified, or the panel report is reversed. The arbitration procedure can also issue recommendations. And the award is then rendered as automatically final with a panel report included. So there's no need to go to the dispute settlement body and get it adopted by the dispute settlement body. The award is, however, notified to the dispute settlement body. And once you've completed this phase, you then return back to the normal dispute settlement procedure, the implementation stage, according to Article 25, Para 4 of the dispute settlement understanding. So a very interesting way to construct what we had before, only through the means of arbitration. And arbitration, as we all know, is a flexible tool that allows the parties to determine for themselves what procedures they like. And here the procedure they like is an appeals procedure replicating what the appellate body did. Noteworthy in that procedure is that the procedure responds to some of the US criticism. So the 90-day limit is reestablished as binding, but the parties may agree on an extension. The arbitrators shall only address those issues necessary for the resolution of the dispute. All of this is in the text of the MPIA that has been notified to the WTO. The arbitrators can also propose to the parties to exclude claims based on Article 11 DSU. If you remember, that was the tool through which claims that were actually claims in facts were turned into claims in law and thus became appealable, something that the US didn't like. So here the arbitrators can propose to exclude that to stay within the 19-day limit. The arbitration award is only binding on the parties. There's an absence of the dispute settlement body. We can discuss whether that resolves the stare decisis issues. I would argue that there is no solution to the stare decisis issue because dispute settlers will always refer to previous cases where they are available. The other interesting point is that the panel roster that had been notified basically consists of people that you would see as possible appellate body member candidates, representing again the range of jurisdictions. There are Mexicans, Swiss, Singaporeans, Canadians, Chileans. And indeed, if you look at the EU candidate, who's Joost Pauwelin, he was nominated in the internal EU procedure as one of 2 possible candidates for the appellate body, and now he's been put on the MPIA instead. Of course, there are no members of states that have not acceded to the MPIA. How relevant is this for the future? At the beginning, there was a debate whether this would just be an EU toy to offend the US, if you want. So you'd have the EU 27 agreeing to it, and maybe the Swiss and the Norwegian. But when you look at the states and see that China has agreed to it and Brazil has agreed to it, a lot of Latin American countries have agreed to it, this is actually becoming a relevant tool. And we now have 9 cases that had an Article 25 notification. 5 of them are at the panel stage. In 2 of the cases, interestingly, the rules have already been tweaked. So the rules notified in the plurilateral solution have been changed in one respect. The panel report is disclosed more quickly to the roster of possible arbitrators to allow them to form their opinion sooner and prepare. Again, this is facilitating staying within the 90 days limit. This is also interesting when you look at it through the unilateral enforcement measures, as both the EU and Brazil have now stated that they would take unilateral measures if a panel report is appealed into the void, even though it benefited them. That basically puts EU partners in a dispute with the EU under pressure to notify an Article 25 approach in a dispute, because otherwise they might be subject to enforcement measures, even if there's only a panel report. And then finally, a systemic issue concerning the whole MPIA mechanism that concerns plurilateralization. There's a problem within the WTO that the 164 members these days cannot agree on anything anymore. Negotiations don't make progress. There are no solutions to problems because one member, as we've seen with the Appellate Body, can block anything. So instead, a lot of progress is made in plurilateral formats where clubs get together and decide that they want to find specific solutions for them. Now, those are not plurilateral agreements as the plurilateral agreements that existed already in the WTO, which are exempted from certain WTO obligations. These exemptions don't apply, but it is nevertheless a sign of members getting frustrated with the all-member approach and instead trying to find solutions in little groupings and teams. Now, all of this was probably the hottest development in the WTO until fairly recently, because now with the Ukraine war, there are two more rather significant developments that I should quickly point out, largely also because they're fairly wrongly reported about in the press. There have been frequent reports about attempts to expel Russia from the WTO or to withdraw most favored nation status. Now, this has to some extent happened, namely most favored nation status has been withdrawn by a group of members, largely the Western powers, the G7, the same allies that act by imposing sanctions in the Ukraine war. But this is all done under existing WTO law. Namely, it's a collective appeal to the national security exception that exists in the WTO, Article 21 GATT, Article 73 of the TRIPS agreement, and I think Article 14 bis, but if I'm wrong, I'm wrong, of the GATS agreement. Those security exceptions are ample, and the states invoking it now say that it allows them to no longer grant Russia most favored nation status. So it allows them to discriminate against Russia compared to other WTO members, which would otherwise violate one of the fundamental obligations of the WTO. And finally, Belarus was in the process of accession. This process of accession has now been stopped. And I think it was 40 members have declared there is no chance of Belarus joining the WTO as things stand. Thank you very much. And I'm ready for your questions.